what do we say about Connecticut? Don't drink the water. Whew, that is a warning. Anyways, we're about to watch a parole revocation hearing for a Connecticut man, and lucky for him, he has Famagetti. Well, he'll tell us how to say the name in a minute. He has, I think, the best public defender in the state of Connecticut. So let's see if he's able to keep him out of prison. With that, let's jump in.
Please state your full name and inmate number for the record.
Daniel Albert, 361570.
Present this morning are Attorney Famagetti. Got it right all day. Go ahead, Mr. Famagetti.
Everybody has a terrible time trying to pronounce his name. How do you spell that again? I'm like family and Getty.
That's actually helpful. Famagetti.
Right.
Absolutely. Go ahead, Attorney Famagetti.
And Public Defender Robert Famagetti of the Parole Defense Unit. Good morning, sir.
And also present is Parole Officer Schaefer. Can you please identify yourself for the record?
Parole Officer Schaefer, State of Connecticut, Waterbury District Office.
Thank you. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. We're now going to review the charges of that the state, your parole officer, is bringing against you and the information underlying each charge. Officer Schaefer, can you please read charge 1, the condition of obedience of law, what you reported?
Charge 1, obedience to law. On August 7th, 2024, you engaged in an argument with the victim over relationship issues resulting from a threesome you had with the victim and her friend. During the argument, you covered the victim's mouth with your hand because she was yelling, then spit on her, slapped her in the face, and pushed her to the bed. You then shut off her phone and told her she was not allowed to call for a ride because you wanted her to spend the night. You then told her she is not to tell anyone of the incident or you would have a female friend attack her, and that you are a Latin King gang member and she needed to respect you. You were subsequently arrested on 8/13/24 and charged with 1 count breach of peace in the second and 1 count threatening in the second.
Thank you. The state has also filed the following exhibits pre-marked for identification purposes. Officer Schaefer, can you read the exhibits you've submitted for evidence?
Give me 1 second. I apologize. Hang on.
That's okay.
Hold on. I'm looking.
I can do it if you don't have it
Yeah,
available.
if you can.
Okay.
Yep, please.
So the state has filed the following exhibits pre-marked for identification purposes. That's Exhibit A, the remand to custody order. Exhibit B, parole conditions. Exhibit C, parole violation report. Exhibit D, the notice of parole violation. Exhibit E, the Waterbury Police Report case incident report number 2400072038. And the arrest warrant application, police case number 2400072038. In addition, the state has filed an addendum for the parole violation report on October 2nd, 2024. Officer Schaefer, do you have that available?
Yes.
Please read the addendum you submitted.
No, I didn't print that out. I apologize.
I have it too.
Yeah, thank you.
You want me to read it? I'm sorry.
Yes. Yep,
Oh,
please.
No problem. The addendum submitted was on October 2nd, 2024, and that reads on October 1st, 2024. Under docket number U04W CR 0510373-S was disposed of. 53A-181 breach of peace second was dismissed, and 53A-62A1 threatening second physical threat was dismissed. Please proceed with the revocation hearing. Mr. Albert, did you receive the notice of parole violation, the parole violation report, and all the other documents I just marked for identification purposes?
I got this.
That's it.
Yes, he got the information.
Perfect. And then in addition, I did receive the defense exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you and your client need any additional time to submit any additional evidence?
No, we do not.
Thank you. Today we have no witnesses. So at this time, it is the state's opportunity to call any witnesses, present evidence, and speak to any of the evidence submitted. Officer Schaefer, do you have any, do you wish to testify on the charges you brought against Mr. Albert?
Yes, I just would like to say that Mr. Albert does have a history of violating protective orders and threatening. So I thought this arrest was significant. All the charges were dismissed, as we did just identify. I don't have any witnesses in this or any further additional information other than what was presented in the violation report.
Thank you. And it's now the defense's opportunity to call any witnesses, present evidence, and speak to the charge submitted.
Yes, regarding the preponderance of the evidence standard, these charges were dismissed. The victim did appear in court, gave a statement. I just received a copy of the statement from his defense attorney today. Didn't have time to put it into evidence, but essentially the state prosecutor acknowledged the charges, and then at the request of the defense, because under the no factual basis prong, the charges were dismissed. They made a finding that there was no factual basis for the charges to go forward. The victim was not the complaining witness. It was someone else that called the police, one of the other parties that was mad at the defendant. They admitted lying about the allegations. And so the charges were dismissed. The defendant, and so those are my comments as to the preponderance of the standard. I don't believe of the evidence. I don't believe a finding there's enough evidence or any evidence for the finding to be made. Thank you for your time and consideration.
Thank you.
You're welcome.
All right.
Can you hear us, sir?
Can you hear us? Okay.
Yeah.
All right. So I am going back on the record now, and I will be going over the findings. So I do recognize that the charges of breach of peace second and threatening two were dismissed. However, I do not feel like it negates the behavior that occurred. So I do find that for charge number one, you violated your conditions of obedience to law based on the evidence provided in support of the charge. And that's Exhibit B, Exhibit C, Exhibit E, and Exhibit F. Specifically in Exhibit F, there is a statement from the victim that states that you slapped her in her face, spit on her, and pushed her onto the bed, which does meet the elements of the crimes. In addition, Officer Schaefer mentioned that there is a history. So that is my finding. And that concludes the finding portion of the hearing. So before I make my recommendation, the state will have the opportunity to speak to your background and history. And after the state is finished, you'll have the same opportunity. The purpose of this part of the revocation hearing is to help determine what outcome I will recommend. So Officer Schaefer, you are now, do you wish to make a statement regarding Mr. Albert's violation, background, and history at this time?
Well, like I said, as far as the history goes, he does have a history of threatening and violating protective orders. At the same time this case was going on, he had a simultaneous case going on, which received an unconditional discharge for threatening in the second. While he's been on parole, he has been compliant outside of these new charges. He hasn't received any misconducts, and he was working. So those are some good things about Mr. Albert there. But again, just to go back on what we're here for the violation, I just feel that this pattern is what is to be noted.
Yeah. And counsel, do you wish to make a statement regarding Mr. Albert's violation, background, and history?
Yes.
Thank you.
A court and a prosecutor dismissed these charges in their experience and their duty to protect the society, dismissed these charges because the victim admitted she lied. What happened in my client's? Sir,
Yeah, thank you.
Listen, What happened in my client's past has no bearing on whether or not something in this case happened. It's illogical to conclude because something's happened in the past that this incident occurred. That's illogical. There's no basis to conclude that this occurred. My client is 32-year-old male. He's single. He receives his support from his boss, family, and friends. My client attended Cheney Tech School where he studied welding. He worked full-time at Parole Gas, full-time at Furniture Factory Warehouse, and was working detailing on the side with a friend at the Right Touch LLC. He would work an hour or two after work there, so he was working 2 jobs. He participated in the Explore program. He completed 23 of 26 sessions. Excuse me. He completed Explore in the past in 2020. He also worked with Hang Time, which is a 2-hour gathering held at our Bridgeport, New Haven, and Waterbury locations. Participants with a safe and respectful space to openly discuss their experiences and challenges with similarly situated individuals and connect to essential services. They were assisting Mr. Albert attaining clothing and equipment for his job at Parole Gas. He was on a maximum contact schedule with good regularity of contact. He was receiving medical assisted treatment. He wishes to be placed in a halfway house in Waterbury. He had absolutely no sanctions and was compliant with parole, and the charges were dismissed. He can return to the Furniture Factory Warehouse to work. And after he's settled in the community, he'd like to return to Parole Gas. And he's always able to do the detailing job. I'm requesting that he be released on November 7th. There's absolutely no basis and no reason to hold him any longer. He's been incarcerated now since August 13th, 2024. And I'm not sure if he's had any prior violations of this parole deal. I don't believe he has.
Last time I got early termination.
Thank you.
This is the first time I was able to capture my exes on film. This is the only reason it's got dismissed. My domestic history was on the basis of being with 2 older women that know the system, and once they don't get their way, you know what happens. In all of my relationships, besides these 2 older women, I've never caught a domestic. And the whole reason this one happened was because my girl tells her friends my name. Okay, if it wasn't for that, then we wouldn't be here. Oh, he's on a bracelet. Let's lock him up.
There's absolutely no basis to further incarcerate my client. Thank you.
Thank you. So I have listened to the testimony and I've reviewed the evidence submitted. And based on that, I do recommend that your parole be revoked and then you serve an approximate 3-month sanction which is a re-parole date of November 13th, 2024. And I recommend the following conditions: no alcoholic beverage consumption, behavioral management program for domestic violence, no contact with your victim TG, a general no contact with TE, halfway house placement, and you mentioned Waterbury, correct?
1 second. You mentioned you wish to be placed in Waterbury, correct?
Yes.
Okay.
Okay.
I have my protective order is fully dropped, and I'm currently still with TE. She's like, that's
There's no charges.
we're engaged. Yeah, we're engaged. Like, that's not.
You're not. So are you ordering no contact with TE?
A general no contact with TE without PO's permission. I can.
So you can't contact TE unless your PO gives you permission, sir.
Because you're in.
That's an order of parole. That's their recommendation. It's not an order of the court, but you still have to obey that.
So what?
It means that when you're on parole, you can't contact TE without your prior permission of your parole officer, even though you're engaged.
So she has to contact you guys?
No,
what do we do?
no, what I just said. You have to contact your parole officer and
Okay.
ask if you can have contact with her. Not
Okay.
every time you have contact with her, but you speak to your parole officer when you're released and you say, hello, the charges were dismissed. I wish to have contact with my fiance. She wants contact with me. what is your position? And if the
Okay.
parole officer says no, you call an attorney,
Okay,
but you call a private attorney, okay?
all right. Also, I have a second question. I was kind of judged on this narrative of this case when I got released from the halfway house to Reach.
What's the question?
I heard I was kicked out of Reach indefinitely.
I don't know. I don't know if you've been kicked out of Reach. Your parole
Yeah.
officer advised.
Yeah, okay,
Your parole officer, when you're released on the 13th, if the board goes along with this, the board still has to adopt this recommendation. And I think they're meeting on the 7th.
They are meeting.
So on November 7th, the board will meet. If they adopt these recommendations, your parole officer will contact you and you'll do what he or she tells you to do, period.
okay, all
Okay.
right, that's
All
fair.
right. 1 minute, she may need to say something to finish the hearing.
So yeah, I'm just going to conclude the hearing, okay? So just finding my recommendations, they will be forwarded to the board as your attorney just stated on November 7th, 2024. And you should receive the official written notice from them shortly after. And just so you're aware, the board may lessen the recommended sanction. They may let the recommended sanction stand, or they could impose a longer sanction than what I've recommended. If they want to do a longer sanction, there's something called a supplemental hearing, but you will be notified before that and the reason for it as to why they want to revisit the sanctioning, okay?
Okay,
Any questions now?
So what you should do is call us on November 8th.
okay,
Or have your girlfriend call us on November 8th.
all right,
And
we'll
we'll
do,
tell you what happened on the 7th, okay?
okay,
All right, good luck, sir.
all right, thank you.
This
Well,
concludes the
that's all good
revocation
then.
hearing and I'm going off the record. All right, you're all set, Mr. Albert. Thank you. Thank you, Officer Schaefer.
Thank you.
Well, told you he's a good attorney, and man, sometimes an attorney, that's important. That's what you need to keep you out of trouble. So before I even unpack this case, we're going to jump to another one where maybe this guy should have stuck with his attorney. Let's jump in.
So, sir, you have important rights to the hearing, which I'm going to review with you now. You do have the right to be represented by an attorney. You may hire your own attorney, and if you cannot afford one, you may qualify for an appointed attorney to represent you. Were you informed that you can be appointed an attorney in this case?
Yeah,
Okay. Do you wish to seek an attorney, or would you like to proceed with the hearing without an attorney at this time?
it's fine. You can go.
So, just to be clear for the record, you do not want an attorney at this time?
Nope.
Okay, thank you. So, sir, you also have the right to receive written notice of the charges of the violation. Did you receive the packet with the charges?
Yes.
You also have the right to review the evidence against you for this hearing, and you have the right to submit evidence in support of your case. At this hearing, you also have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand all of these rights?
Yep.
Thank you. So, sir, now I'm going to review the charges that the state and your parole officer is bringing against you, along with the information underlying each charge. So in regards to charge number 1, conditional bail laws drugs, the charging officer reported that on 7/18/24, parole staff was conducting a search of your person and located a syringe in a blue elastic band, commonly used to inject illicit drugs, in your left pants pocket. This is a violation of conditional bail laws. Specifically, I will not use or have in my possession or control any illegal drug, narcotic, or drug paraphernalia. In regards to charge number 2, additional conditions halfway house placement, the charging officer reported on 6/26/24, you signed on the Watkinson halfway house located at 136 Collins Street in Hartford at 2:12 p.m. to attend a 3 p.m. scheduled work shift at Salute Restaurant in Hartford. At 3:50 p.m., a supervisor from Salute Restaurant informed Watkinson halfway house staff that you did not show up for your scheduled work shift, and the supervisor had made multiple attempts to contact you with no response. This PO attempted to contact your cell phone and left a voicemail requesting a call back. You did not return to the Watkinson halfway house. Calls to local hospitals and police departments produced negative findings. You did not list an emergency contact with the halfway house. This PO was informed by the supervisor of your place of employment that you had went there on 6/27/24 and picked up your paycheck. Subsequent attempts to contact your phone or locate you at local hospitals or police departments were unsuccessful. Your whereabouts in the community were unknown until parole staff and the Bristol Police Department located you living in a tent in Bristol on 7/18/24, and you were returned to the custody of DOC. This is in violation of your halfway house agreement. Specifically, I will only go to the locations indicated on an approved community pass, and and I will return to the Halfway House from Community Pass at my scheduled return time. So the state also filed the following exhibits, which I'm going to remark as status exhibits for identification purposes. I have Exhibit A, the parole violation, notice of parole violation signed by you on 7/19/24. Exhibit B, notice of parolee rights, again signed by you on 7/19/24. Exhibit C, the remand to actual custody order dated 7/18/24. Exhibit D, PCS signed conditions that were signed by you on 4/16/24. Exhibit E, Halfway House agreement signed by you on 4/15/24. Exhibit F, Watkinson Halfway House incident report dated 6/26/24. Exhibit G, Watkinson Halfway House abscond report dated 6/26/24. And Exhibit H, photos of drug paraphernalia with no date listed. Exhibit I, the parole violation report dated 7/23/24. Sir, did you receive the notice of parole violation, the parole violation report, and all the other documents that I just marked for identification purposes?
Yep. Yes.
Thank you. And to my knowledge, I don't have any defense exhibits on your behalf, correct?
Nope.
Okay. And you don't have any witnesses today?
Nope.
Okay. So, sir, this is now your opportunity to respond to the parole violation and charges against you. However, please remember that you may remain silent at this time. If you want to make any comments with regards to the charges, you may do so now.
Nope.
No comment? Okay.
Nope.
Okay, so I am going to announce my findings at this time. So in regards to charge number 1, conditional bail laws drugs, I do make a finding of probable cause based on the evidence presented in support of the alleged violation of parole, which includes Exhibit D, the parole conditions, Exhibit H, the picture of drug paraphernalia, and Exhibit I, the parole violation report. On charge number 2, additional conditions halfway house placement, I make a finding of probable cause based on the evidence presented in support of the alleged violation of parole, which includes Exhibit D, the parole conditions, Exhibit E, the Halfway House agreement, Exhibit F, the Watkinson Halfway House incident report, and Exhibit G, the Watkinson Halfway House absconder report, along with Exhibit I, the parole violation report. So at this time, I do find that the acts are serious enough to warrant revocation. I have also determined that you should be detained while you wait for your revocation.
I don't want a
hearing.
revocation hearing. You guys can go yourselves. All you guys. I got 5 months left. I'm done.
Okay.
Bye. Don't even talk to me. Thank you. Got 5 months left. You guys.
Whatever 85 is, 85 get
Okay. For the record, the Mr. Hornberger just walked out of the room prior to the conclusion of the hearing. This concludes a preliminary hearing, and I'm now going off the record.
Thank
Whatever. F you, Lindsay. You freaking.
Okay. I had to throw in the Lindsay thing. It's been a while. But for those of you who know, you know. If you haven't seen the hearing, I don't know. I'll put a link to the description below. That guy was something. So the one who we just saw, who chose not to have an attorney, he actually got a 5-year sentence for robbing a bank. Isn't it interesting that in Connecticut you can actually get 5 years for robbing a bank? And the man before him, if you were curious about his crimes, Sir Richard Hazard, he's got a long record. Let's see, he's got arrest after arrest after arrest, a lot of violation of protection orders, controlled substance stuff, but nothing huge, I guess, but he did have problems with his threesome and whatever. And the woman who told his name, I didn't get to unpack that, but there's not much to unpack, but it's like, he's still going back to her. Look, it's the water. It's in the water, but we'll go for another one, won't we?
Hello, money.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony in today's hearing will be taken under oath. Ms. Gonzalez, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. First, I will read your rights. Then we will review the parole violation charges that the state your officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to conduct cross-examine adverse witnesses. Do you understand these rights?
Yes, I do.
We now review the charges that the state your officer is bringing against you and the information underlying each charge. On charge 1, program participation, a no finding was made at the preliminary hearing held on July 31st, 2024, and will not be considered at today's hearing. Charge 2, obedience to the law. On July 12th, 2024, during your remand to custody by parole staff, you turned your head and spit directly at the face of the escorting parole officer. Based on your actions, you are in violation of Connecticut General Statute 53A 167C, assault on public safety, emergency, medical, public transport, or health care personnel. On July 12, 2024, during your remand to custody by parole staff, you were placed in the back of a caged parole vehicle for transport to a correctional facility for females. Immediately upon transport, you began to thrash and throw your body and head against the cage of the vehicle. You successfully manipulated your wrist restraints, causing you to no longer be restrained in an attempt to interfere with the transport to a correctional facility. Based on your actions, you are in violation of Connecticut General Statute 53A 167A, interfering with an officer. Charge 3, no consumption of alcoholic beverages. On July 1st, 2024, you consumed alcoholic beverages as evidenced by your voluntary admission of alcohol use. On July 10th, 2024, you consumed alcoholic beverages as evidenced by your voluntary admission of alcohol use. On July 12th, 2024, you consumed alcoholic beverages as evidenced by your voluntary admission of alcohol use. The state's exhibits were identified and marked at the preliminary hearing on July 31st, 2024. Counsel, did you receive the notice of parole violation report, and other documents that were marked for identification purposes?
Yes, I have.
The defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today, we have no witnesses, and it is now the defense opportunity to present evidence or speak to any of the evidence submitted.
Yes, charge 2. The conduct did not rise to the level of arrest. It's clear she spat at the face. That's the allegation. She didn't spit. She was actually, that's one of the days where she had admitted to using alcohol. Charge 3, July 12th. She, once upon learning that she was going to be brought to jail, she got sick. And she did not spit at anyone. She did nothing to get at the face of the officer. She was out of control in that she was getting sick as they were trying to take her into custody. And then the attempt to interfere, it's an attempt. She was brought to prison. She was transported to DOC. She did not flee. She did not run. So I don't believe it meets the preponderance standard. Thank you.
Charge 2, obedience to the law. I make a finding based on state's exhibits A, D, L, N, and N. On charge 3, no consumption of alcoholic beverages. I make a finding based on state's exhibits A, D, E, F, and I. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Counsel?
Yes, my client's first violation of parole, she was out for approximately 3 years. I understand that her max date is 10/30/24, but she would like to be out prior to that max date. That is her wish. She, while incarcerated, was going to groups. She was in the methadone maintenance treatment program. She's single. She's 42 years of age. She receives her primary support from her sister, Vivian. She has 4 sons who reside with their father in Uncasville. She has her CNA certification, and she had been working for 1.5 years in the past as a housekeeper. She also worked as a CNA for compassionate care homemakers, and was employed at the time of the remand and can return upon her release to that job. She worked in the script program in the past. She was involved at Silliman House. She was participating in weekly case management. She worked with a recovery coach at CCAR. She was in the MAT program in the form of methadone. She was also received intensive outpatient program and medication management at the Root Center. As I stated earlier, she was second chance reentry and
I recommend a revoke with no new parole date, which is an approximate 3.5 month sanction. In the event that the board chooses to lessen the recommended sanction, I recommend the following conditions: no consumption of alcohol, no contact with co-defendant Wayne Wells, Dawn Martin, and Samuel Vasquez, halfway house placement in the event that it's needed, and mental health evaluation. My findings and recommendations be forwarded to the board. You will receive official written decision from the board, and your board review scheduled on October 3rd, 2024. The board may lessen my recommended sanction, let my recommended sanction stand. And if they let my recommendation stand, you'll go to your end of sentence. Okay, which is on October 30th, 2024.
that's the end of the hearing. Okay, so the board's going to meet on October 3rd. So call me on or after that day. Okay,
All right.
and I will let you know when you're going to be released. Okay.
All right, thank you so much.
You're welcome, Maria. Good luck.
Okay.
I wish you the best of luck. Okay.
All right, thank you.
And the attorney strikes again, Mr. Family. Let's hear it from the.
I'm like family and Getty. Family Getty.
Thank you.
F you, Lindsay. You freaking.
Okay. Anyways, I mean, like it's this revocation hearing. We've seen her before, and let's see what is she in for? Maximum 10/7/2001 is when she was sentenced, 4 years. Maximum release date says she had gotten paroled. What was she in for? 2/7/2018. So failure to appear, suspension of sentence, probation. I don't know. Did his attorney really say that she was sick and that's why she's bad? It's you hear it all, but I mean this is why you kind of have a revolving door in the state of Connecticut, right? I mean, I don't know. Let's see. I mean, Sir Richard does have stuff in her larceny. It seems like a lot of petty stuff, but do you want to see another one? Do you want to see another one? If you like these short revocation hearing stuff, let me know in the comments section. It's it would mean a lot to me.
Because we didn't receive it back in the mail. So my advice to you for today is if you want the public defender's office to represent you, that either you need to return the application if you received one, which you should have received one, or we will attempt to schedule another phone call with you to take it over the phone. But you would need a continuance for today's purposes so that we could do that. We obviously are not prepared to represent you today. Your other option is that you could go forward and represent yourself. So it's certainly your choice.
I think I'm willing to go forward and represent myself. Basically, I just want to tell my side of what happened, so that there's an understanding.
Okay, Mr. Mathewson, then we have to go through a whole procedure.
Right.
So Attorney Jones just wanted to let you know your status with her office. But as long, like you and I are not gonna talk, she's free to go.
Can I just inquire in regards to his violation? Is he charged? Is it just technical or is there an obedience to the law?
They are just technicals.
It's technical. And then how many?
2.
2. Okay. All right. So you're sure you're comfortable going forward on your own?
Yeah.
Okay.
I never been through something like this before, but at the same
Okay.
time, I really want to try and get back out to the community and keep moving forward. I don't want to delay this if possible.
Okay. Just wanted to make sure. Good luck, sir.
Thank you.
Thank you, Attorney Jones.
Yep. Thank you.
Okay, then Mr. Mathewson, we're gonna start, okay? Sorry I'm
Okay.
late today. I do want to apologize. I am running behind, but I appreciate that you've been patient. You were aware I was running behind, but I have been.
Yeah.
But we are gonna start this process. And we are gonna go over some rights for it as well. So you'll have the opportunity to figure out if this is still something you want to proceed with today, okay?
Yeah.
All right,
I'm just
perfect. Well,
I'm just
yeah,
a little I'm just a little nervous and a little anxious. I've never been through something like this, and I made an honest mistake. I
yeah.
wasn't trying to do anything malicious, so I'm really hoping that I can go back out to the community. That's my goal, and hopefully, if I'm able to explain what happened, maybe they'll be a little more understanding.
And we're gonna get to a point in the hearing where you're gonna get to state your position on the charges, okay?
Yes.
All right, so are you good for me to start?
Yes.
Perfect. So I am Parole Officer Tricello, and I'm a hearing examiner for the Board of Pardons and Paroles. And this is a preliminary hearing concerning James Mathewson, inmate number 307247. Today is Tuesday, October 1st, 2024, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Hartford Correctional Center. Please state your name and inmate number for the record.
James Mathewson, 307247.
This is a public hearing. The public has access to this hearing, and it's available via live stream, video live stream, okay? This is a preliminary hearing, and there's a few purposes for this hearing, and I'm going to go over them with you. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say in this hearing can be used against you. The hearing is being recorded. The testimony at today's hearing will be taken under oath, so can you please raise your right hand? You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Perfect. So we're going to go over the procedures for the hearing, okay? First, I'm going to read you your rights, and then we're going to review the parole violations that have been charged against you by the state, your parole officer, and then I'll review and identify exhibits filed for the record. The state is not present today at today's proceedings. However, you will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my finding, which will be based on all the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
Great. So you do have some rights to this hearing, actually quite a few. So the first right is that you do have the right to be represented by an attorney at this hearing. You may hire your own attorney, or if you cannot afford one, you may qualify for an appointed attorney to represent you. We just had the discussion with Attorney Jones. Would you like to seek counsel at this point and continue your case to be represented?
No.
Okay, so you're okay with moving forward with that representation?
For now, yes.
Okay. You have the right to receive written notice of the charges of violation. Did you receive the written notice?
Yes.
You have the right to review the evidence against you before this hearing, and you have the right to submit evidence in support of your case. In addition, at this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
So we're now going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So on charge number 1, condition of restriction of pornography, the charging officer reported that on the following dates, September 11th, 2024, September 12th, 2024, September 14th, 2024, September 15th, 2024, September 16th, 2024, and September 17th, 2024, you viewed graphical erotica images and or searched pornographic erotica content on your Motorola Edge cell phone under the Google account james.com. Based on these findings, you violated your parole condition that states you will not access, view, or possess any graphic material by any means, print or electronic. On charge number 2, conditions of problem sexual behavior treatment, the charging officer reported that after notifying the Connections CTPSB program of your behaviors that violated your parole condition, the program negatively discharged you from their program. The state has filed the following exhibits, pre-marked for identification purposes, as Exhibit A, parole conditions, Exhibit B, notice of parole violation, Exhibit C, parole violation report, Exhibit D, remand to custody order, Exhibit E, the IPPC report from parolee Mathewson's Motorola Edge cell phone, Exhibit F, pictures taken of search content from parolee Mathewson's Motorola Edge cell phone, Exhibit G, the Connection CTPSB discharge report, and Exhibit H, the Connection House discharge report. Did you receive the notice of parole violation, the parole violation report, and all the other documents I just marked for identification purposes?
No, I did not.
You did not receive any of that evidence?
No.
Okay, would you like to continue this hearing to receive that evidence?
No. I don't want to continue the hearing.
So you wish
I
go
know.
forward
Yeah.
without reviewing any of the documents?
Yes.
Okay. You have not listed or filed any exhibits for yourself, correct? No evidence on your own?
No.
Okay, and do you wish more time to do that as well?
No.
Okay, so again, we're okay with moving forward at this point?
Yes.
Perfect, thank you, Mr. Mathewson. So there are no witnesses here today. So at this point, it is your opportunity to respond to the parole violation charges against you. However, remember that you do have the right to remain silent if you choose to do so. So at this time, would you like to testify regarding your case, and would you like to respond to the charges?
Yes.
Go ahead, now's your opportunity.
Okay, so I received this cell phone. Oh, I purchased this cell phone. I guess I received it. I purchased this cell phone, and there was a stipulation that I had to put an electronic monitoring device on the phone. I complied and put an electronic monitoring device on the phone. The Wednesday that of the week of which I bought the phone, I went to my CTPSB group at 2:30 in the afternoon. During the group, I addressed Morgan Kelly. She's the woman who runs and facilitates the group. I asked her, I have this phone. What am I allowed to view on the phone because I have the restriction? I said, if I watch a movie and nudity pops up or something like that, is my phone going to be taken away from me? Am I going to get into trouble? She then said she was not sure. She emailed my supervision, and then before the end of the meeting, she told me that she had received a response and that it was okay for me to view adult nudity and adult nudity. I said, are you sure? I said, I'm not sure that's all right. I said, who did you email? She said she spoke with Anne Marie Moosehorn, who's my probation officer. At that point, she turned her computer and showed me that she had a response saying that it was okay for me to view adult nudity and adult pornography on my cell phone, and that she explained to me that the monitoring app would block things that I'm not supposed to view. So at that point, I was under the impression that she had fully contacted my supervision team, and she had pointed out probation officer Moosehorn as a point of reference. And I went back to my halfway house. I then sent her an email, or not an email, I sent her a text from my phone to her work phone that she uses for the connection to contact the clients. I sent her a lengthy text saying, look, I'm really not sure about this. I'm going to test the waters, but I feel like I'm nervous and anxious about searching this stuff because I'm not sure it's 100% okay. I said, I'm going to test the waters. Please message me back. I also called Anne-Marie Moosehorn to verify. I left her a voicemail saying, hey, can you please call me back and give me a verbal verification that what I am doing is okay? I don't want to get in any trouble. I then waited a few hours and I got no responses to the text or the voicemail. So I figured, from my experience, if nobody contacts you, that means nothing bad has happened. You haven't done anything wrong. So I proceeded to go online and I viewed some Google pictures, and it was nothing like socially inappropriate. It was standard adult stuff, nothing crazy, nothing fetishy, just standard run-of-the-mill stuff. I proceeded to view it a little bit each day. And then my point was, and I never got to do it because I got remanded when I was supposed to be headed to my next CTPSB meeting. I was literally headed out the door when Parole Officer Norton told me to not leave the halfway house to go to my meeting. And my point when I went to that meeting was to show my phone and the content to Morgan Kelly at CTPSB and say, hey, look, this is the stuff that I was looking at. You guys said it was okay. I just want to verify that this type of content has been okayed. I then received a phone call from Anne-Marie Moosehorn about 10 o'clock or 11 o'clock. I was walking around. I was on Main Street. I was in front of Liberty Bank, and I received a phone call from Anne-Marie Moosehorn on my cell phone the day of that I got remanded, saying that that the images in the video that I viewed on the 11th and the 12th were the dates that she specifically told me in my ear. That she said her exact words were, "You're in the clear." So I said, okay, cool. And I was gonna be going to my meeting. Again, I had to swing by the halfway house to pick up a backpack with my CTSB assignment work in it. And when I got there to pick up the backpack, Mr. Norton had told me over the phone, don't leave the halfway house. I have to come meet with you. I said, am I in trouble? He says, no, you're not in any trouble. He says, I just have to come meet with you. So I waited around the halfway house, and at that point, they remanded me. But what I'm getting at with all this is I did these things under the impression that I had permission. I did not know that my parole officer had sent them an email after the fact stating that I am not allowed to do this and that he is not allowed to change that stipulation. So I didn't do this maliciously. I didn't do this because I was trying to be sneaky. I did it with the honest intent that I thought I had permission to do these things. Now, moving forward, I'm not denying that I looked at this material. What I'm saying is I thought I had permission to, and if I had gotten that message from Mr. Norton on time saying not to, I would not have looked at it. I'm not trying to screw up coming back. I've been out of prison for almost a year with no incidences, and I was working on getting my disability set up. I have a lot of extreme medical issues, and I was like going to physical therapy. I'm about to find out whether my disability is approved or denied, and I'm not trying to screw all that up. So what I'm asking for from the board is a little bit of understanding that if they let me out and send me back to the community, this is not going to be a repeated mistake, because now I know that, you know, and I've heard from my parole officer, Mr. Norton, that he's not able to change that stipulation, and that he did send them an email after the fact stating that I was not allowed to view that. But by that time, I'd already viewed it. So what I can say to the board is, if I'm let out today and I keep doing the monitoring on my phone, they will clearly be able to monitor my phone and see that I'm not going to be accessing adult material as long as that stipulation remains in line. I will fully comply with it. I have no problems complying with it. And this was an honest mistake, not something malicious or trying to be sneaky. So I'm nervous because I've never really gotten in trouble since I've been out. I'm not trying to get in trouble. And since I've been in prison, I've had to go to the hospital for emergency care because I had a bowel obstruction, because they can't.
Just know this is live stream, so just keep your health.
Yeah, that's fine.
Private, okay. So I do notice and recognize you have been to the hospital.
Yeah, and
Since your remand as well, yes.
Yes, and what my point behind that is that the DOC and these facilities cannot adequately take care of my medical care or my medical needs, and therefore I frequently have to go for emergency care because they can't handle it in here. And being in here is putting my health in jeopardy. And I know this, and that's motivation for me to not want to come back to prison for, what I consider a dumb mistake. And that's a dumb mistake on my part, but I try not to make these mistakes. I try and stay on the ball, stay vigilant and of like when I'm out in the community, I think to myself all the time, is this gonna violate a parole stipulation? Is this gonna cause a problem? If so, don't do it. And I have this thought process about a lot of different things. I constantly report to my probation and parole officer if I have indirect contact, direct contact. I talk in group, I communicate in group, and I do my assignments. I'm active with that. I don't avoid anything. So in my static 99R score, my recidivism reoffense score is a 2. I have the paperwork showing it's a 2 out of a 10. That's extremely low. I'm at a low to moderate risk of reoffending. So I think these things could be taken into consideration, and I'm confident that if they give me a chance and let me back out into the community, there won't be a recurrence of this issue.
Thank you. And I did take lots of notes of your testimony, Mr. Mathewson. So just to be aware, the standard for this preliminary hearing is probable cause. So we just have to determine whether or not you committed these acts, if there's a likelihood of it. So I'm just going to review the testimony. I, like I said, took a lot of notes. I just want to look over it one more time and read some of the evidence. I'll get back to you with my findings of the violation, okay?
Yes, ma'am.
Thank you.
The court actually treat this as an actual escape from prison, or is it just like big up?
Oh, there's one other thing. I know you're following us. I would also just like to make it known that when the parole officer asked me to stay in a halfway house, I knew I was being remanded to custody. I did not run. I did not try and flee. I've been cooperative. And since I've been in prison, I have not been in any trouble. I've been cooperative as the best of my ability dealing with the situation. So I just want to make that known as well, that, I've been doing my best to not cause any waves since this happened.
Noted, definitely noted for the record. Okay, so again, the purpose of a preliminary hearing is to establish probable cause towards the violations brought against you by your officer in the community. So going through your charges, I do make a finding of probable cause for charge number 1, condition restriction on pornography based on the evidence provided. Exhibit A is your parole conditions that you signed on January 9th, 2024, which indicate that you acknowledge the said conditions, specifically restriction on pornography, and that you will not access, view, or possess material by any means, print or electronic. And Exhibit C, the parole violation report dated September 27th, 2024, which includes detailed information about the charge and the various dates you viewed images, as well as information from your charging officer that they met with you on September 13th. And again, directed you to not view pornographic images.
She's in HCC.
And then Exhibit E, the IPPC report from your Motorola Edge cell phone, which provides detailed information about the dates and time material was searched on the cell phone. And lastly, Exhibit F, which are numerous pictures taken from the search content of your Motorola Edge cell phone. I also make a finding of probable cause on charge number 2, conditions of problem sexual behavior treatment, based on the evidence in support of the charge. And that includes Exhibit A, the parole conditions signed by you on January 9th, 2024, which indicates that you acknowledge the said condition, specifically the condition of problem sexual behavior treatment. The violation report dated 9/27/2024, which includes additional information about the negative discharge from the connection CTPSB program. And lastly, Exhibit G, which is a discharge report from the connection CTPSB program, which provides detailed information about your unsuccessful discharge from the said program due to the viewing of inappropriate sexual material and non-compliance with your parole stipulations. So this does conclude the findings, and I do find that the acts are serious enough to warrant revocation. And I've also determined that you should be detained while you await your revocation hearing. The records office at your facility and your parole officer will be notified of this. Do you have any questions at this point?
HCC.
Like, I'm just curious, like, how long am I gonna be in prison for?
So revocation hearings have to take place within 60 days of remand, 60 business days of remand. So at your revocation hearing, that will be the hearing that myself or another examiner will determine if you violated the conditions of your parole. And if so, the examiner will then make a recommendation regarding whether your parole should be revoked and if a sanction should be imposed. So at the next hearing, you'll have another chance to discuss the charges, submit your application for the attorney if you still wish to, and then they will discuss any sanctions that might be appropriate for the violations if they find that you violated them at that point. Okay.
So
The revocation hearings are ideally held within 60 days, or they are.
yeah, I
within-
understand that. I don't understand why I can't be in the community while I'm doing this. I'm not a risk. I'm not going to reoffend. Like, my phone is monitored. You know, I'm worried. I'm really worried about my health in here. I'm really scared that, like, my health. I've already been in the emergency room once, and they're still not doing anything to take care of my health in here.
I do understand your concerns, Mr. Mathewson, and I did, like I said, note them, and I am aware of your recent trip as well. However, the charges brought against you are serious enough to warrant a revocation hearing, and that's at the point that we're at, and you'll be scheduled for one within 60 business days of your remand. Okay?
Even
You'll
with
be given notice of all of this.
All right, so I sit in prison for up to 75, 90 days because it's business days. They don't count the weekends. So I sit in prison for 75 to 90 days. And then, like, what kind of time, if I get sentenced to an actual thing, what kind of time am I looking at?
So the hearing examiner will provide you with a recommendation at your revocation hearing, and it's based on the charges, the information provided from the charging officer, as well as if you do have a defense or if you want to provide any evidence, you're more than welcome to for that hearing as well. And that decision is determined at the hearing after speaking to all the parties involved in reviewing the evidence again. So there's no way I can tell you. But then that recommendation goes to the board members at the Board of Pardons and Paroles, and they get to review it and ultimately make the decision as to the appropriate sanction. So as of today's hearing, it was just to establish probable cause and if your charges were serious enough, which was what happened today. So you will be notified of what happened today, a disposition, a decision, all that information, and then your hearing will be scheduled within the 60 business days for the revocation, okay?
So at this point, I do want representation. So am I going to be allowed to do that? Because, and when my parole officer came to serve me the paperwork, I did put on the paperwork somebody that I wanted to call to the Senate. I put Morgan Kelly's name on that paperwork and like where she worked. I couldn't remember her contact phone number, but I put the information as best I could on that paper.
So with the representation, you can, Attorney Jones gave you the instructions, right? So send in your application right away.
I don't have an application. I don't have it. Nobody's mailed me any paperwork. I haven't received anything.
Okay,
this facility is not running the way it's supposed to. Like,
okay.
when
So
I went to the,
I'm going to have my supervisor. No, I do understand you've been around also, and that could be a confusion with it, and that's part of it. So I'm going to have my supervisor email Attorney Jones's office, the public defender's office, and let them know that you are requesting representation for your revocation hearing. Okay.
yes.
100%. Anything else at this point? We kind of went over stuff, and your attorney will reach out to you. They will reach out to you for the application process. As Attorney Jones mentioned, can be done over the phone with their office. Okay.
Yeah. No, I'm just like, I'm not denying the act. What I'm asking for is understanding and a little bit of mercy. You know, to understand that if I go back out in the community, I'm not a risk for hurting anybody. I only did this because I thought I had permission. I didn't understand that until after the fact that my parole officer had sent an email saying, no, don't do it. And that happened after the fact.
Yeah.
So, you know, I'm just trying to get a little understanding and a little, like, basically mercy on this, because I didn't try and go out and commit some malicious act. I wasn't trying to go out and do some creepy thing. I genuinely, you know, it was a miscommunication and a misunderstanding, and it's something that's easily resolved. And just keeping me in prison and with all the stuff that I have going on out in the community that I'm trying to accomplish that's positive and moving forward, it seems like a bit overkill to me. And I don't understand. All that stuff that I was working on is going to be basically thrown out. And if when I get out of here and get put back in a halfway house, I'm going to have to start it all over again. And some of these things take up to a year. And, you know, I want to move forward with my life, not backwards. So that's why I'm having trouble understanding why the board is so passionate about keeping me in prison. You know,
well, again, Ms. Mathewson, this hearing was to determine probable cause on your violations. You did sign your parole conditions as discussed in January, so you were aware. So this hearing is just to determine whether or not the actions took place and the seriousness of it. So at this point, the preliminary hearing is concluded, and at the revocation hearing, you can work with your attorney once you get established with them, and you guys can state your case at that point about the revocation, okay?
Yes, ma'am.
All right, thank you so much. You have a great day, Mr. Mathewson.
Yeah, sure.
This concludes the preliminary hearing, and I'm now going off the record.
All right.
All right, you are all set, and you will get all of this information in the mail, okay?
Mm-hmm.
All right, take care. Have a good day.
Thank you.
Thanks.
What a clown. And let me tell you what he did and how crazy this is. Thank you, Sir Richard, for providing the information. It's insane. Okay. And the very idea that he's making an excuse like, I didn't even know I could watch that material. His initial crime involves showing that material, okay, showing adult content to 3 different girls, 6 years old to 9 years old, and then touching them. He only got, for doing this to 3 little girls, right? He was sentenced or convicted June 23rd, 2014 for 3 counts of SA. And I'll go through the details, but just to give you an idea, he was paroled November 6, 2023. For 3 victims. He's barely out. Okay. I think maybe he even didn't get released, or he signed the contract on January 9, 2024. He's not even out. He's out like a handful of months, and he's sitting here saying, "Oh, I didn't know I couldn't watch it. Oh, just wait." It's now we're gonna eventually watch his full hearing when he comes up and whatever time it is. We're also gonna go over that low risk score that he says he has, which is just perfect. I mean, if we needed to tie up this parole hearing with the bow, that was it. When he starts talking about his risk, I have a 2. It's a low risk score. Yep, it's a static 9-9. It's the collaborative 10-point questionnaire. We're going to go through it that all 50 states use that. Yeah, accurately would have put him at a low risk score and a low chance of recidivating. Yeah, look how long this clown lasted. Now, I'm going to read to you what he did, and it's barbaric. So 29-year-old man is scheduled to be sentenced today to 10 years in prison for allegedly, they say, is that still something you say when you're being sentenced? Let's see, for allegedly will be sentenced to 10 years in prison for SAing 3 young children. He also faces 10 years of special parole and 35 years probation when he is released from prison. We'll go over to see exactly how much he got for that and how much time he's backing. And he must register as a sex offender for the rest of his life. He is likely to face strict probation conditions, such as no unsupervised contact with children without advance permission. Why would they even give any permission? Random searches and requirements that his home job and romantic relationships be approved by authorities. They respect the authority, right? Mathewson agreed to a plea bargain June 23rd in London Superior Court. He pled guilty to reduced charges to 3 count of first-degree SA and 1 count of risk of injury to a child, because why not give plea deals? Who cares? He's a low risk to reoffend. He also pled guilty to violating a protective order. Oh, wow, just throw that in there. What's the big deal? Police said that in March, while he was in prisoner awaiting trial, he sent letters to a person covered by the order, which forbids him to try to make contact in any way. And they still gave him a deal. But we're not surprised. Mathewson pled guilty under the Alford Doctrine, meaning does not agree. Wow, just give him everything on a silver platter. Maybe or whatever. Okay, he admits the evidence of what happened, but he admits the evidence exists to convict him at trial. According to the arrest warrant affidavit, 2 of the children told a babysitter on February 21st that Mathewson had touched them, leading Lanyard police to investigate. In separate interviews, the children, ranging ages between 6 and 9, said that Mathewson had improperly touched them numerous times and had showed them adult videos. Clown. One of the children reported performing oral on him. Oh. The children said the abuse began years earlier. Oh. And this is the cockroach that the DA, that the judge gives a 10-year deal where he is paroled after serving what? He served what? You know, I really can't. I just you know, you can't make this stuff up. You really can't. The idea that he would get such a light sentence, years of abuse to little children, then, you know, it's great. It's great that the low risk score, somehow it didn't add up, right? The math didn't add up. So he somehow reoffended. Here's the low risk score. And we'll Well, for those of you who haven't seen it, but this is the 10-point questionnaire that all 50 states use to assess a risk. And what it is the lowest the score, the better. And according to the score, so the lowest the better. Now here's how it works. If you are age 35 to 40, which was his age at the time that he committed the crime, let me see, no, he was 29. So 29, he would actually be a 1. So he gets 1 point. Now, if he had been 35, 0 points. And if you're 60, -3, because we all know that when you're 60, your chance of reoffending it's so low. You start with -3 points. Remember, the fewest points, the lower your risk. Have you lived with a lover in the last 2 years? If you have, 0 points, which we all know. Of course, nobody who marries, women for their stepchildren can be any risks, right? Non-sexual violence, any convictions, 0 points. Prior convictions, 0 points. Prior sex offenses, 0 points. He had none of those, right? No priors. Prior sentencing dates, no. Any conviction, no contact. That might be having CP. No. Remember, he had nothing. No one knew about him yet. So 0, 0, 0, 0, 0. Any stranger victims. It could be, or any male. By the way, if you have a male victim, you get a point. But if you don't, it's a 0, because we know that makes a lot of sense. So he said he got 2 points. So 2 points would have been 1 for age 8, because he's under the age of 35 at the time. And he would have gotten 1 more point, and probably any unrelated victim. So he'd get a point for that, because they weren't related to him, assuming that. So that's how he has 2 points. That's how he's a low risk. And according to the static 99, which all 50 states use, by the way, because now he's a low risk or moderate low risk, the chance of reoffending, dun 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 dun, would be 1% to 2.6% after 5 years. Wow, I wonder how. I guess he's in the 1 percentile, and his excuses are just, of course, it's what you'd expect, right? I had no idea. Meanwhile, in his initial charge, he's showing it. It just drives me nuts. So his full sentence here, Sir Richard has it: convicted 3 counts, illegal. So it's 16 years with the special parole. So, that's how much time he's backing, I guess. But we all know how this stuff works, is that he'll be back up for parole. Even they might just sanction him also. We'll see it in 3 months when we watch it. They might just give him a 6-month sanction. He gets out, right? It's not like he gets a 5-year. It's not like Louisiana where they revoke and you serve the whole sentence. So the whole thing's a joke in Connecticut. They revoke, you get a sanction, then you get back out, and then you revoke. We see it over and over and over. So many, like dozens and dozens of revocations. Sir Richard's been he's suggesting that we cover just a revocation series of all the different states, because like Utah, we could see people revoked 5, 6, 7 times in 4 years. It's the whole thing's a gimmick. But yeah, I mean, classic depiction of a cockroach right there. And frankly, I'm happy he chose not to have an attorney. Funny, I tried to squirm his way out of that at the end. Oh, I didn't know. But there you had it. We saw a bunch of different revocation hearings. This one, of course, more serious than the others, but at least it had a happy ending. And make sure to subscribe if you want to see the follow-ups, because we will cover him when he comes up for his next official hearing, when he has an attorney. And I hope he doesn't have, what's his name?
I'm like, family and Getty. Family and Getty.
And with that, I'll let you go.
Got 5 minutes left. You guys.
I'm like, family and Getty. Family and Getty.
Once upon learning that she was going to be brought to jail, she got sick. And she did not spit at anyone. She did nothing to get at the face of the officer. She was out of control, and that she was getting sick as they were trying to take her into custody.
And my static 99R score, my recidivism reoffense score is a 2. I have the paperwork showing it's a 2 out of a 10. That's extremely low. I'm at a low to moderate risk of reoffending.
F you, Lindsay.